Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jeffrey Hare. Jeffrey is an attorney, has his own law firm, which is a professional corporation in San Jose, California. He provides client-focused, outcome-oriented legal services to his clients. He's also a licensed real estate broker and real estate investor. Jeffrey specializes in real estate law, real estate property transactions, entity formation, commercial leases, loan documents, land use law, zoning, and land use changes, municipal law, and mediation services. That's a big mouthful of stuff there, Jeff. Keeps you busy, I guess. Anyway, today we're going to be talking about settling legal disputes out of court, which is also known as alternative dispute resolution. And as we get started, I want to caution our viewers again that we're discussing issues in a complex area. This is just a starting point for a bigger discussion with your own attorney. And so, Jeffrey, thank you for joining me as my guest today.
My pleasure.
Okay,
my pleasure, Michael.
Good having you. All right, well, let's go ahead and get started with our questions. How do disputes typically even arise?
Well, you have to stop for a minute and think about how things get started in a dispute. And oftentimes, people have expectations of an outcome from a business partnership or some agreement, and things don't work out quite as they planned. And that's pretty normal. Another way that disputes arise is where there's something not clear as to whose responsibility it is to do certain parts of a business transaction. And of course, real estate transactions, there's always issues with things that were not properly disclosed and things that cost more than expected. But disputes also arise when things work out better than planned. Sometimes the parties end up with a huge success, and all of a sudden the pieces of the pie become more valuable.
How are you going to divide the spoils?
That's right.
Okay. Well, what are some of the what are some of the typical costs of litigating a dispute?
Well, you obviously have the more obvious costs are things such as attorney's fees. I call the hard cost, the filing fees, and the cost to do what's called discovery, which is the process of getting documents and taking depositions of the parties and getting the witness statements so that the resolution of who said what and when, who promised what, all has to be well documented for trial. There are some hidden or intangible costs as well, and that is the lost time. A business owner caught up in litigation is going to have to take time away from their work to prepare for the trial, to prepare for the information. Also, they become distracted, and it's an emotional event and many times because of the relationships that are involved. And last and not least is if it's real estate, for example, you often end up with a frozen transaction that nothing can be developed with the property sometimes for years.
I guess one other thing, cost that we haven't talked about is the cost of the relationship possibly between these people. So sometimes you get into these disputes and if they can't be solved in a very amicable way, then it could be the end of a friendship.
That's true, and it extends even to large corporations that are continue to do business together. And part of the resolution of the dispute sometimes is to look forward and say, what could be done going forward in their relationship that is beneficial for both parties?
Yeah. Just when you were mentioning that, it popped in my mind this situation that happened with Hewlett-Packard, not so long ago, when their president basically had to leave and then goes with Oracle, and then Mr. Ellison says not very nice things about Hewlett-Packard, and also, I guess, sort of reneged on some of their contracts or something. I don't know.
That's true, and like Apple and Samsung are two of their best customers, and Google and Apple work together in the Valley, and all over the world. But even on a much smaller scale, once you have a business relationship, it's very likely you're going to have a continuing one, and that's part of the negotiations that often goes into the transaction.
Mm-hmm. Okay. So What are the main forms of alternative dispute resolution? How are they different?
Well, let me start by saying alternative to what? We've described some of the cost of
Yeah.
litigation, obviously, and taking a case to trial involves a huge expense with an uncertain outcome. And so many years ago, the process was looked at carefully to see, is there an alternative way to resolve disputes? And the first one that came up was arbitration. Now, arbitration is basically a way to get a decision about the case by an independent, neutral third party who will rule on the case. They'll hear the information from both sides and issue a ruling, but with less formality than in the courtroom. This ruling could be either binding or non-binding, depending on what the parties have written into their contract. The other form is that's becoming much more popular nowadays is mediation. Mm-hmm. In mediation, the mediator does not make a ruling. It simply helps the parties themselves to come to a resolution of their dispute, and to set it up that way is probably more efficient and more informal, and is now becoming more popular in some of the standard contracts.
Okay. Well, let's say a contract has an arbitration clause. Should you just go ahead and sign it, or what do you think?
Well, that's a big question. Normally, it's optional. In most real estate contracts, there's a separate place for the signatures of the parties if they agree to arbitration. But if you are a business person, you often have contracts for things like your copy machine or for services that you get. And you'll start to see more and more where the arbitration clause is mandatory. And you waive your rights to a jury, and you waive your rights to go to trial. And you must go through arbitration before you even attempt to do litigation. So the caution that I sound here is you have to be careful and read it. Arbitration, again, initially was viewed as a good alternative to litigation. But arbitration has become so cumbersome with rules and structure that sometimes it's could put you in a worse position than if you were to litigate. One example, a lot of arbitration clauses say that the venue for resolving the dispute may be in the home state of the company you're doing business with. So two California business people will find themselves having to travel to New Jersey or Texas or somewhere else to resolve their dispute. That's a huge expense. Mm-hmm, mm-hmm.
There's also a thing, and maybe you can comment on this, but I thought I saw some litigation to the effect, and I think it actually probably related to a stock brokerage firm, but it was like, this is their standard contract, and if you want to do business with them, that's what you have to sign.
Right.
And so it says more or less you must arbitrate, and then after the fact, this person was damaged, and they went to court and said that really should be disregarded because they didn't have any choice.
Well, one point that's coming out is that the arbitration clauses themselves are coming under greater scrutiny. The courts have generally upheld the arbitration clauses because they're part of a contract between two business people, and they've upheld them even if the result is something different than they might obtain in a court of law. Mm-hmm. And the Supreme Court just agreed to hear a case on certiorari that involves an interpretation of the language of the arbitration clause itself that was somewhat vague, and the question was whether or not the arbitrator exceeded their jurisdiction. Again, it comes back, be careful what you sign, consider the consequences before you do it. You should, again, consult with an attorney who say, should I sign this arbitration clause? What impact will it have on me if I have to use it?
Mm-hmm. Okay. Well, what are the primary advantages of mediation?
Well, I've mentioned one, it's informal. It allows the parties to work together to come up with their own solution, but it's also confidential. Mediation provisions are, by definition, under California law. The parties are free to discuss their solutions, make concessions, and attempt to reach an agreement. All of that is confidential and may not be held at trial. But the key advantage of mediation is that the parties are free to do whatever they want to do. They can throw out the old contract, write an entirely new one to adapt to changing circumstances. As long as they get it in writing at the end of the mediation session, they can move forward with their business relationship. Arbitration, by contrast, is limited to the fact that the arbitrator could only rule within the scope of what was in the contract between the parties.
Okay. So what are some steps that you can take to resolve a dispute even before you go to a lawyer?
Well, one of the first questions I always ask rhetorically, if nothing else, or I'll ask my clients, is this a business issue or is this a legal issue? In other words, is the basis for the dispute something that is can be resolved by making some sound business decisions, or is there really a legal issue involved? That's one thing. The second thing is I always ask people to consider how much is at stake. One of the things that's sad to see is a dispute that's gone on between two parties over let's say 4 years of litigation over a $5,000 security deposit that wasn't returned. And at the end of 4 years, they've both racked up $150,000 in attorney's fees. Again, yes, there's a legal issue buried in there, but mostly it's a poor business decision to litigate to that extent. Also, I ask clients to consider, how did they get to this point? If they know how they got into the situation they're in, there's usually a roadmap for getting out. Somewhere in that pathway, if they can identify more clearly how they got there. And also, I ask them to focus, what is the objective? What's the outcome that they want to achieve? Aside from all of the other stuff that goes on, you have to keep that in focus or you can waste a lot of money. And last, are you seeking justice or revenge? So often we get upset and emotional with a dispute that has arisen or a deal that's gone bad. You can waste a lot of money trying to seek revenge. And I think that if you stick to the facts, stick to your objective, you'll have a better effect for a lot less money.
Mm-hmm. I'm just thinking through a little bit of some of this, and sometimes it seems like, some of these things that end up being expensive litigation matters, big lawsuits, what have you, sometimes they can maybe even be solved just by somebody apologizing.
Yeah, you would be surprised. I teach negotiations at Santa Clara Law School, and one of the major treatments in one of the chapters in the textbook goes to great lengths about studies that have been done about the apology. And it's clearly a factor in all negotiations that if a party has done something that is viewed by the other party as something wrong, then an apology can go a long way. It definitely can helps the other party accept the terms, even if it's not exactly what they wanted.
Yeah. So, because although you were talking about business and legal, but a lot of these things they're really sort of personal. We're talking about people's feelings. We're talking in some cases about I guess I can say a feeling of injustice or an opinion of injustice. When you talk about somebody fighting and spending $150,000 over a $5,000 deposit, there's something beyond the $5,000 that's going on that's
someone
causing
needs
this.
I would say someone at that point needs counseling more than they need legal work.
It feels that way an awful lot of the service business is that we end up being counselors. I guess that's why they call maybe lawyers counselors. Okay, well anyway, is there anything I can do when I'm setting up a business that can help me to reduce my risk of exposure?
There's a lot you can do. I think the number one thing and the exercise that drives most people a little bit batty is come up with a business plan. Sitting around with a cocktail napkin or at the coffee shop, verbally people have put together an idea of what they want to do. They've got a great idea and it's going to make lots of money. Being forced to write a business plan, by forcing the exercise of writing it down, can really help you start to spot some of the issues they come up with. Some lenders require a business plan, so you're going to have to do it anyway. But if by writing it down, who's responsible for what, how you're going to meet your expenses, how you're going to deal with your contingencies, the mere exercise of writing this down will force you to think through some of the processes so that you can start to guard against contingencies and other issues that could happen. A second thing is to consider the proper entity. Even sole practitioners today are forming, as you mentioned, my law practice is a professional corporation. Limited liability companies are extremely popular for both providing some degree of protection, of asset protection. But you also want to think about it as a nifty accounting process. In other words, by setting up a separate business entity of some sort, even a sole proprietorship with the proper accounting is better than an individual just doing business out of their living room. I think that the maximum asset protection, to achieve that, you do need an entity of some sort these days. And most business people recognize and accept people doing businesses through an entity. Last but definitely not least, is to consult with professionals. If you're about ready to invest $100,000 or $200,000 of your life savings in starting a business, it would seem that it would be worth it to take a couple of hours' time to consult with a CPA and an attorney. Because I know in your profession and in mine, we see a lot of failures, unfortunately. We see a lot of businesses that have gone bad. So sometimes we can help those clients in advance by warning them of things that they should consider, things they should probably do, things they should have in their business plan to head off some of the problems that our other clients have suffered from.
Mm-hmm. There's another thing that came to mind as you're going through your list, because thinking of my personal situation, where I've had disputes and so on. Fortunately, nothing serious where I've ever had to go to court and so on. But an awful lot of it just comes from really spelling things out. In other words, having a good agreement, and so that people know what they can expect, and then delivering on that. So there's, unfortunately, including myself, but there's an awful lot of agreements, that we leave things open, like, I'm charging $4.50 an hour. Well, that's nice. How much is that going to be?
Right.
Is it going to be $900? Is it going to be $20,000? What's it going to take to get this job done? And so if you can come to agreements about these things and spell it out in advance, then it's going to increase the comfort level, hopefully on both sides, where you can come up with something that's acceptable for both of you.
Absolutely. I think one of the things that people, they've been a fishing buddy or a golfing buddy has gotten together, or, your best friend, and you have sat down to do a business deal, and you've kicked it around while you've gone on your outings, and you think this is going to be great. And it doesn't matter. It may very well be the greatest idea in the world. But again, if it was written down and you have it clearly laid out, the expectation of both sides is there. I emphasize that it's important that these, when you write these down, they have to be realistic goals. Mm-hmm. And sometimes someone, like you said, when you tell them what your rate is going to be and you tell them what you're going to attempt to accomplish, you probably don't have any idea how much time it's going to take. However, if you can sometimes give them a ballpark of how much time you're going to take before you come back to them, and then the person themselves can decide whether or not to go further in that relationship. Mm-hmm. But major business commitments like a lease for 5 years and setting up, investing heavily in furniture and all the things you do when you're starting a business, without a business plan that may collapse in the first week, you're still liable for that 5-year lease agreement. You're liable for the expenses of the furniture. Mm-hmm. So before you jump in, they should have these things laid out and save them a lot of grief.
Okay. So I think that sort of leads into asset protection. And it's something I think that's on a lot of people's minds, but maybe you can clarify, what does it mean from the lawyer's standpoint, and what are things that people can and should do?
Well, first of all, there are a lot of people out there selling something. It's a version of snake oil. It's called asset protection, and they will set up these elaborate schemes that supposedly will protect you in the event that you're sued. under a lawsuit. And at the end of the day, I find a lot of investors have spent more money on asset protection than they have on the assets. So what is assets? Well, assets are basically items of value. It's an accounting term, but it's is a practical definition I like to use. It's an item of value that either produces income or it has some equity beyond its liability and expenses. And a lot of people, if you understand that, it's something worth keeping. Now, how do you protect that? Well, one of the things is if you have some personal assets, things of value, and through your business operations, you become exposed to a major litigation matter, and there's not enough insurance to cover it, you could become exposed to be liable for that. And what happens then, the plaintiff, the person who is suing, comes after you. They can get some of these assets that you want to protect. So the way to do that is to isolate them into different entities is one way to do it. But before you get there, I think the important thing is, one is to have good management practices. Two is to have adequate insurance coverage. And then third, think about that entity formation that I mentioned earlier. So that if your personal assets are protected and you operate your business inside an entity, then you can protect both your business and your personal assets.
Okay. Now, if I do set up a business entity, does it make any difference which state that I set it up in?
Well, if you listen to some of the advertisements out there, everybody loves Nevada and Delaware. You know, this
They're very
the
good
best
about
thing in the world.
promoting.
And you'll find that a lot of people will rush out and set up these entities in those states, either because they feel they're going to save from having to pay certain taxes in the state of California, or if it's supposedly, it's rumored that if you have a Nevada LLC, somehow or other it's going to provide better asset protection than a California LLC. Well, we don't know that, of course, in any instance, but it is most important to understand you have to do this within the state you're doing business. So regardless if you register your LLC or your corporation in the state of Delaware, if you're doing business in California, you're going to have to register that entity in California, and you're going to have to pay those fees anyway. I'll leave it to you to explain the tax consequences, but the point is that the state does matter, and if you're going to be doing business in California, save yourself the trouble, register in California and set it up, and you'll be fine.
Yeah. So one popular business entity right now is the single person LLC.
That's right.
And so, you know, it's just you folks, and what happens is it's a disregarded entity on your tax return. That means it's just
for federal purposes.
Well, and for California, there's a special little form that you file for an LLC, but still the income ends up on your individual income tax return. As an individual, you're taxed on your worldwide income as a California citizen, a resident, and so it's not going to save you much tax-wise. It's the
right.
asset protection that we're talking about. You know, liability protection is more of the benefit of the entity right there. And then, like you said, possibly having it build to more business organization. Yeah. Okay. Well, we don't have a whole lot of time left, but maybe you can throw out, if a dispute arises, what are some key negotiation strategies to consider?
All right. This is always something. Negotiation is the way that all disputes are solved. 95% or more of all cases settle before they go to trial anyway, so everybody at some point ends up negotiating. First is, as I mentioned, keep your primary objective. Second of all, consider what's called your BATNA, or your best alternative to a negotiated agreement. That's what's going to happen if you don't settle. In knowing realistically what is your alternative. For example, your alternative may be a long, lengthy, costly trial. So if you know that, then going into your negotiations, you'd probably be more inclined to reach a reasonable compromise settlement. You should start with your highest legitimate expectation. If you come to the table with something that's unrealistic or over the top, the other party's simply going to walk away because there's no incentive for them to negotiate. Very important when you go into a negotiation, ask questions and use active listening. make sure you're listening to the other side. Sometimes the other party is going to be willing to give you more than you expected, but you won't know it if you're doing all the talking. Distinguish between high and low value items, and I think that it's always important that at some point in the discussion, if things become overheated, take a break. Just go walk to the balcony, come back into it, and you'll get to the resolution. And make sure to get everything in writing. Absolutely, when you finish any type of negotiation, get everything in writing and you'll be fine.
Okay, good. So we really only have about a minute and a half left. Maybe you'd like to just throw out a final piece of wisdom here related to this area of dispute resolution.
Well, one of the things, of course, as an attorney, I see a lot of people spending lots of money on attorney's fees. I hear about that when they call me and they tell me how much money they've spent to the previous attorney, unable to resolve the case. I find that I try to listen to what my clients are trying to achieve, and by focusing on an objective or a goal, it helps to eliminate the options that are not going to get them where they want to go. Mm-hmm. And that is probably the single biggest issue that I have my clients focus on, because it's easy to get lost in the weeds, as they say. And I think that's very important that if you have that objective and you have a business goal and you have a business plan, you'll end up saving thousands and thousands of dollars.
Great. Jeffrey, thank you so much for being my guest today. It's a pleasure having you. Folks, I hope that you've gotten some food for thought here, and if you follow and apply these ideas, I think that and you do get in a dispute, they can save you many thousands of dollars, and maybe even more than that. So, we'll see you next time on Financial Insider Weekly.